welcome everybody. If you didn't already do so, just take a look at this prompt on the PowerPoint and take a moment to answer that, and I'll turn it over to Jeff to get us going. Thanks, Jeff.
No problem. Thanks, Sandy. Good afternoon, everybody. My name is Jeff Coover, and I'm an educational consultant out of the Patton Pittsburgh office. I want to welcome all of you to one of this afternoon's post-conference sessions, What Would You Do?, which is being facilitated by Sandy Shacklady White, a Patton education consultant out of our East office. As many of you know, the session is 60 minutes in length and is being recorded. The session has closed captioning available. If you need to utilize the closed captioning, just please click on the CC button at the bottom of your Zoom link toolbar. By this point, we should all know where the session information and handouts are, but I will put that link in the chat in just a few minutes. Again, we want to welcome you. Sandy is going to take us through the next hour, and we're excited. This is when we do our face-to-face conferences, this is one of the most well-attended sessions that we have, and probably one of the most informative in terms of some information and knowledge that you can take back to your LEA. So Sandy, we're going to let you go ahead and get started, and welcome everybody.
All right. Again, welcome everyone. Glad you're here. You are in the session, What Would You Do? We're going to be examining 2 Pennsylvania due process hearing cases as if you were the impartial hearing officer. And as Jeff said, I am an education consultant out of the Patton East office, and I'm happy to be with you today and having prepared this for you. If you're like me and Jeff and some of my other colleagues that I know are on here, we're geeks when it comes to reading these cases and learning from them the best that we can. So welcome, and we will be using breakout rooms and a Padlet, and Jeff will be popping in some links and uploading some documents so that we're hopeful that everybody can be participating.
I'm going to start here tomorrow and then go over to admin.
Okay. As you know, Patton's mission is to support the efforts and initiatives of the Bureau of Special Education and to build the capacity of local education agencies to serve students who receive special education services. And PD has a commitment to LRE. Our goal is for each child to ensure individualized education program teams begin with the general ed setting with the use of supplementary aids and services before considering a more restrictive environment. To get jumping in there, we want to take a look at due process cases 2 from this past year that I decided to focus on, and just kind of a refresher about 2 categories of violations that are found in cases or not found, such as procedural and substantive. Procedural errors or violations is where a district violates one of IDEA's procedural requirements. Most do not by themselves result in a denial of FAPE unless one of the following conditions or more is evident. It impedes the child's right to FAPE, significantly impedes the parent or guardian's right to participate in the decision-making process to provide FAPE to the child, and or causes a deprivation of educational benefit. The hearing officer would be unlikely to award comp ed, may direct an order to remedy the violation such as staff training. Substantive errors, on the other hand, or substantive violations, automatically result in the denying of FAPE, may result in an award of comp ed or tuition reimbursement or some other significant relief. Key areas could be obtaining parent input, conducting or not conducting comprehensive evaluations, poor identification of present ed levels, maybe a lack of developing measurable goals and objectives as applicable, perhaps not providing the related services and supports that are needed for that child based on the evaluations and data at hand. What you see in front of you here is a diagram that I am using with Perry's or Kell's permission, and I have a link there, and I also have on the Padlet that Jeff will be giving you a link to soon, the actual article that it comes from in 2015. You will see here that Perry put into figure 1 the key components of special ed litigation. And I just think it's a great visual. It shows the framework for the article. As I said, it's in the Padlet, and it's serving as the culminating hub of the central pillar of IDEA. It's the statutory obligation to provide each eligible student with FAPE. Leading up to this pillar are the overlapping components of child find and eligibility, interconnected by evaluation. On the other side, and covered elsewhere in the article, are subordinate IDEA components that interlock with FAPE, such as the statutory preferences for LRE, or that flow from denials of FAPE, such as the primary remedies for denials of FAPE, tuition, reimbursement, and comp ed. Each of the remaining parts of the article explains the components and identities and their interconnectedness and the nuances. And I just think it really encapsulates the legal findings while we're looking at individual cases. Okay. A quick word before we get into the summaries. The summaries that you will have access to are based on real due process cases here in Pennsylvania in the past year. Keep in mind that many of the details have been omitted from the actual hearing officer's decision because I wanted to keep the case studies brief with only having the 1 hour with you. And I am providing you with key information as much as possible. While we can learn from each case that we read or hear about, whether it's today or when you're looking at other cases, every case has unique facts with case-specific determinations made by the impartial hearing officer at that time for that individual student. Okay, you can access the Padlet using the QR code, or Jeff's going to pop that in the chat, which he has done. And what we are going to be doing is taking a look at case 1, which Zoe B versus the PA school district. I just made it a random name of Zoe, has nothing to do with the case, that name. And the school district, again, it's based on an actual case. I just am not identifying the specific PA school district that this is connected to. So we're calling case 1 Zoe B versus PA school district. What you're going to do is access the Padlet, which you can do through the chat, and on that Padlet, you are going to see the case summaries. There will be a block that has case 1, the summary, and then there's also case 1 breakout room slides. So you're going to see at the top on the Padlet, they're green, case 1, and then case 1 breakout room slides. You're going to go into a breakout room for 12 minutes. Our awesome text person, Joel, is going to just randomly assign those. You will take 12 minutes to read the case study that's less than 2 pages. You're going to discuss as a group after you read the 2 components. There's the family part of the case, as if it's their perspective of what's going on. Then you're going to have the school district's piece in the case. And then you have to answer questions. So in the Zoe case, you will read that information, and then as a group, you will discuss the answer to should the district have identified the student as a student with an intellectual disability? If so, did the district deny FAPE? And then in addition, did the school district deny Zoe FAPE when she was at the private school? You will decide then as a group, if it was yes or no. There are 3 choices there under what do you think? Yes, yes, or no with some reasoning. And then discuss in your breakout room as per the case summary. So you're going to have 12 minutes. We will bring you back. Make sure that you decide on your answer and also indicate on the slide that's your room. So again, make sure you're looking at your room number when Joel puts you out there so that you can go to the slide on the breakout room slides or Google Slides to put your group's chosen answer under the what do you think, and then putting in the right-hand side of the slide your 2 to 3 different recommendations or key takeaways, key things that you've learned from reading the case and your discussion. You'll be with about 10 people in each room, and we'll bring you back in about 12 minutes. Okay, we've got a couple people putting stuff in. Some are saying answers 2 and 3. Group 5 was torn between numbers 1 and 2. Recommending that school teams ensure information on why disability categories were or were not applied should be included in reports with data included. Good recommendation. Group 1, a key recommendation, be communicative with a private placement school having ongoing IEP meetings to make sure programming is effective. Group 4, also torn due to limited information. As I said, you would have limited information. I'm going to give you more information in a minute. The case study focused on reevals. Take another minute to pop in anything else that you came up with so that you'd like to share out with. Before signing a contract with a private school, who's responsible for the reeval? Team 8, they were in favor of the parents of the students. Ensure that reevals fully explain why the eligibility category is chosen by the school team. Similar recommendation. Group 8 thought the number of goals was insane. I have to agree. It got up to 19 for the information in the hearing decision document. Okay. All right. Well, I'm going to share with you. This is when you know a parent is mad, angry. Yeah. Okay. Well, the actual answer is number 2. And I'm going to share a little bit more information with you that the parent, as you know, asserted that the school district failed to accurately identify Zoe's disability as an intellectual disability until a certain stage in what was going on in her high school years. Zoe's in high school at this point in time and had been in the school district since she was in kindergarten. The flaw that was found here by the hearing officer is that they did not identify Zoe with an intellectual disability. And in most cases, it's stated almost always then it's a denial of faith because it circumvents the heightened awareness and added protections in Pennsylvania for students with ID. One such protection is short-term objectives under the goals. Another flaw, ID requires that a reeval is done every 2 years versus 3 years. So that's a denial. Flaw number 3, disciplinary protections. Any removal due to disciplinary situations must be done through a manifestation determination review. So in this case, while number 3, that third flaw about a manifestation, there was no disciplinary issue here. Factors 1 and 2, especially that lack of a reeval every 2 years, is a huge factor in that denial of faith. So while the school district provided faith in the design and implementation of the IEPs, they failed to meet its necessary obligations for that reevaluation process, and therefore they did not properly identify her with that intellectual disability. And as a result, the hearing officer fines for the parents in this situation. The order that came out in reality in terms of the details, because of the misidentification issue, 100 hours of comp ed was awarded. There was also a question about transportation, a very small issue with transportation not being provided for Zoe due to the lack of a bus aid for a few days. So between the 100 hours of comp ed and the 15 hours that were awarded as an equitable award due to the transportation missing due to no aid, there was a total of 115 comp ed hours that were awarded. So you're looking at, if you were to, take a ballpark figure of $85 per hour and multiplied that by 115, you're looking at $8,600, probably higher in terms of those comp ed rates. So that is the outcome on Zoe. Okay, so hopefully that has warmed you up and we're ready for case number 2, which I see Joel has popped into the chat for you. We are now going to take a look at a case that is the PA School District versus SID. So in this situation, the LEA has filed for due process against the situation involving SID and SID's parents. So that is in the chat for you. We're going to do the same process where you're going to go out into breakout rooms for 10-12 minutes. We're going to keep an eye on that. You will see on the Padlet the blue tiles that have case 2 summary if you want to look at it that way. It's also on the website. You're going to use the breakout room slides that are on the blue tile that are on the Google slides. Use those to record your answers. And Joel's going to send us on back out. All right, welcome back, everybody. Good to see everybody. Hopefully you had a good discussion on case number 2, PA School District versus SID. Hey, just like last time, if everybody could put in the chat the answer that your group chose, and then one of your key learnings or recommendations, just pop it in the chat. Okay, leaning towards number 2 and a 1. Not sure. So it's kind of mixed between 1s and 2s. And what about your recommendations from this case? I know there was limited information, but what would you say would be something you could take back to your team, back to your school district? Offer an independent eval. Importance of building relationship. Reconvene the IEP team. That was one of my sayings when I was a special ed administrator, was when in doubt, have an IEP meeting. Document. Hey, any other information? Oh, there goes another one. Concerned about the gap between the full evaluations. Yeah, it had been 6 years in this situation. So the answer to this one, somebody said school districts should provide evidence of progress and effectiveness of specially designed instruction. Someone else has asked, did the school district offer to extend the goals for another quarter? Request mediation, offer an independent eval, communicate clearly the need for an evaluation for 504 to ensure eligible for special ed. Yeah, eligibility issues. Okay. Another question is, the school district trying to protect itself by showing why a 504 would be appropriate? Yeah. Well, the answer is number 1. I see Danette dancing over there. Yoo-hoo! You know. And I've got an OMG and Janetta, yay. Okay, so the answer is number 1. The school district has proven in this situation that it should be granted the relief being sought, which is conduct the reevaluation. And just to give you some information on that, this is a very contentious case. Some of the comments that are in the hearing officer's decision, quite interesting. So according to the details, the proposed reeval from the school district is comprehensive and reasonable and would be conducted by qualified professionals. So it is felt by the hearing officer that a reeval is needed to determine Sid's continued need for special education or not. And the parent, there's information about the parent's testimony and submission of evidence and the post-hearing brief that was submitted, that the parent submitted in her brief items that were included in the brief but had not been presented as evidence at the hearing. So those items were then not part of the hearing officer's decision. The parent who claims that she has knowledge of special education claims that the school district is not required to conduct the assessments, but the issue before the hearing officer is whether the information, the assessment being sought is needed to determine Sid's needs, and if Sid meets eligibility criteria for an IEP. While the parent was claiming that the district did not need to conduct the assessments, there was no citation of any legal authority to support that opposition to the reevaluation being proposed by the school district. The parent's brief contained a lengthy discussion of settlement negotiations. So it sounds like the parent was suggesting, how about a development of a 504 plan? Again, that was not the question before the hearing officer, so it's not being considered in this hearing. And the hearing officer even stated, if it was considered, it's not a basis to say that the school district does not need to do proposed testing. As a result, the hearing officer found that the parent's arguments were not persuasive and that the district has met its burden as to this issue. The parent testimony also was noted to be not consistent with that of the school district staff.
We're 5 minutes out.
Thank you, Jeff. The parent claimed that the school district did not articulate the purpose of the testing, yet later on in the parent's testimony, the parent stated that it was needed. In quotes, this hearing officer there is a toxic relationship between the parent and the school district. Parent stated that she does not trust the school district, and also quoted from the hearing officer's decision, it appears the parties have lost sight of the fact that we are talking about the education of a young person. Furthermore, SCOTUS, the Supreme Court of the United States, has noted that the special ed process is to be collaborative in nature. And although the parties have the right to utilize any procedural safeguard provided by IDEA, they are strongly urged to consider using mediation or a facilitated IEP meeting to help repair their relationship in the event they have another disagreement concerning the student's education in the future. And they went on to say that a wealth of resources related to less adversarial methods of dispute are available at the Cadre website. So the order from the hearing officer is that the relief was as requested by the school district is granted, and they are to conduct a proposed reevaluation of SID, including all the assessments proposed therein. So there you have it on that one, and we've got 4 minutes left. Hopefully you enjoyed the discussion. I greatly appreciate everything that you all do out there in the field every day with your students, their families, your staff, your colleagues. And again, applause to all of you for everything that you do every day. I appreciate your time for being here. Hopefully you'll learn something and we'll come again, and maybe we'll be in person next time. Back to you, Jeff.
Thanks, Sandy. Folks, before I give the code for this session, just keep in mind that Act 48 is being awarded to participants who attended or who attend the full afternoon today. So if you're wanting Act 48, you'll need to consider going to the next session from 2:30 to 3:30, which is practicing presence, balancing life, work, and everything in between, which I'm sure pretty much everybody in this room would admit that we probably all need. So please consider going to that one again, starting at 2:30 if you want Act 48. I'm also going to put, after the code, I'll put the credit verification survey link in there for you as well. You'll be needing that again for the Act 48. So the code that I'm going to share again in the chat right now for this session is WWYD7. That's WWYD7. What would you do 7? Okay. I'll also, again, paste the verification survey code in, and that's available for you there as well. Thanks, everybody. We appreciate you joining us, and hopefully see you all at the last session for the post-conference, which is at 2:30. Take care.
Thank you.